When you think about it, corporate directors are some of the most powerful people on the planet. They steer these massive companies that, literally shape our world. But what governs them? Who holds them to account? Well, it turns out there's a very specific rule book for these guardians of corporate power, and today we're going to open it up.
So let's just ask the big question right up front. When a single decision can affect thousands of lives, not to mention billions of dollars, who is holding that decision maker accountable? Well, the answer isn't really a person, but it's a powerful legal idea, the concept of duty. And here's the absolute key to understanding all of this. You have to see a director not as an owner, but as a guardian, a trustee. They've been handed the keys to something incredibly valuable that isn't actually theirs. Their entire role, their entire power is built on one simple, powerful idea: trust. And that idea is the foundation for everything we're about to get into.
Now, you might be thinking this is all just some vague, hey, do the right thing kind of philosophy. But nope. This concept of trust is actually written down, codified into law. In the UK, the main event is the Companies Act of 2006. You can think of it as the ultimate director's rulebook. It took literally generations of messy court battles and legal arguments and boiled all that wisdom down into a single modern guide. And get this, that entire complex universe of trust, responsibility, and power, for directors, it all comes down to just seven core duties that are meant to shape every single decision a director makes.
And here they are, our roadmap for this whole thing. Now, to make sense of them, we're going to tackle them in 3 groups that answer 3 really simple questions. First, are you playing by the rules? Second, whose side are you on? And third, are you actually any good at your job? So let's start with that first one, understanding the boundaries of power.
All right, first up, playing by the rules. This first set of duties is all about the limits of a director's authority. Look, you're given incredible power in this role, but that power is not absolute. Not even close. It comes with some very strict guardrails.
So the first rule of the club is you have to act within your powers. But here's a twist. The why you do something is way more important than the what. It's all about this idea of proper purpose. For example, a director has the power to issue new shares, right? But that power exists to raise money for the company. If they use that exact same power just to mess with a rival shareholder and protect their own job, that's a breach of duty, even if the action itself was technically allowed.
I love this analogy because it just nails the concept of proper purpose. The prefect's power was given for one reason: to improve learning. Using it to hook up their friends is an abuse of that power. It is the exact same principle in the boardroom. A director's powers are tools for the company's benefit, never for their own.
Okay, so directors have to play inside the lines. Got it. But now we get to the real heart of the matter, a question that's even more fundamental and gets to the very soul of the role. When the chips are down, whose team are you really on?
And this duty, wow, this is the big one. Some people call it enlightened shareholder value. It says that a director's primary goal is the success of the company for its members. But, and this is so crucial, they can't have tunnel vision. The law says they must consider the long-term impacts on everyone: employees, suppliers, customers, the community, the environment. It's about building sustainable success, not just chasing a quick buck.
Just think about a football coach for a second. Let's say he wins the championship, but in the process he injures every star player and bankrupts the club. Has he really succeeded? No way. A great director, just like a great coach, knows how to balance winning today with ensuring the long-term health and stability of the entire organization.
Okay, now you've really got to pay close attention to the wording on this next one. The duty is to avoid situations where your interests could possibly conflict. That is huge. This is an incredibly strict preventative rule. It doesn't wait around for something bad to happen. The mere potential for a conflict, even the slightest chance your personal agenda could clash with the company's, is enough to be a breach.
And look, this is not some newfangled idea. This quote from way back in 1896 lays down the absolute bedrock principle. The law basically assumes that human nature is, fallible. So it just forbids directors from even putting themselves in a tempting position to begin with. Your loyalty has to be 100% undivided. Period.
And if you want a perfect real-world example of how strict this is, look no further than the famous case of IDC versus Cooley. So here's what happened. Mr. Cooley was the managing director. An opportunity came up, but it came to him because of his job. He tried to get clever. He resigned, claiming he was sick, and then snapped up the contract for himself. But the court saw right through it. They said, nice try. That opportunity belonged to the company, which means all the profits he made belonged to the company too. A very clear lesson.
All right, so a director has to follow the rules and they have to be loyal. Check and check. But is that enough? I mean, what if they're just not very good at their job? Well, that brings us to our final theme, the standard of care.
This is where the law sets a kind of minimum performance standard. See, being a well-meaning, loyal director isn't quite enough. You also have to be competent. The law expects you to bring a reasonable level of care and skill to the table. And if you don't, and the company loses money because of your negligence, you could be on the hook for it personally.
So how does the law measure this standard? Well, it's actually this really interesting two-part test. First, there's the objective part, a baseline. What would any reasonably diligent director do in this situation? But then there's a subjective layer on top of that. If you, personally, have special skills, let's say you're a chartered accountant on the board, you are held to a higher standard on financial issues than a director who doesn't have that background. The law expects you to actually use the expertise you claim to have.
And this leads to an absolutely crucial point that the courts have hammered home again and again. There is no such thing as a sleeping director. You can't just hide on a board, show up to meetings, and nod along. Every single director is responsible for staying informed and providing active oversight. Pleading ignorance is simply not a defense.
So, we've laid out the entire rule book. But rules are only as good as their enforcement, right? What happens when somebody breaks them? That's when the law steps in, blows the referee's whistle, and calls a foul.
So what's the penalty? Well, as you can see, the remedy is designed to fit the breach. If you took a corporate opportunity, like Mr. Cooley did, you have to hand over every penny of profit. If your carelessness caused a loss, you might be paying damages out of your own pocket. The goal, always, is to make the company whole again.
Now, this next point is maybe one of the toughest, but also one of the most important things to get. Liability here is strict. In some of the most famous cases, courts made directors repay profits even though they acted honestly, and even when the company itself couldn't have taken the opportunity. Why? The goal of the law is pure deterrence, to make the line so bright and so clear that no director is even tempted to cross it.
Okay, so after all that, is there any way out? Is there any room for forgiveness? Can a director ever be excused? The short answer is yes, but it is so rare. A court does have the power to grant relief for an honest and reasonable mistake, but the bar to clear is incredibly high. It is the absolute exception, not the rule.
All right, let's just pull back for a second and look at the big picture. Why does any of this matter so much? Well, these 7 duties are more than just rules. They're the legal framework that underpins our entire economy. They're what ensures that the immense power directors hold is channeled towards sustainable, responsible goals. They are, quite simply, the foundation of the trust we place in businesses every single day.
And that leaves us with one final big question to chew on. We have this incredibly detailed, powerful rulebook. But in the real world, the fast-paced, high-stakes world of business, does it truly guide directors toward better behavior? Or does it sometimes create a legal minefield that punishes an honest mistake just as harshly as deliberate fraud? It's a debate that lies at the very heart of modern corporate governance.